Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland and Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
Welcome to Win with the Law. Learn how to navigate the legal landscape and end up on top with the help of legal community's most prominent lawyers. My name is Gary Newland. I'm a trial lawyer with Newland and Newland LLP from Arlington Heights, Illinois, suburb of Chicago. We will discuss issues and strategies for success so those listening can be empowered to achieve successful outcomes when it comes to legal challenges. Without further ado, I would like to introduce Dave Saxe, an attorney that practices in school law and family law. How are you today, Dave?
Good, Gary. Thank you for having me.
Dave, I was hoping you can enlighten the listeners with just some background as to your life first.
Sure, absolutely. So I became an attorney kind of through a circuitous route, if you will. I worked for about 2 decades in education before going back to school to become an attorney. Worked in schools as a psychologist, an administrator, a coach, and then was encouraged by the attorneys for the firm that represented the school district I worked for to go back to school and become an attorney and go work for them. And that's what I did. It's been a wonderful journey. Worked for them for a couple of years and then started my own practice. And now, as you mentioned, most of my practice is in the area of family and school law, with a little bit of this and that wrapped in as well. Also a parent of 5 amazing kids who certainly help inform my practice and my work I do for kids and families. And the work is incredibly rewarding.
It's nice. Now, tell me more about your practice. What does it consist of?
So it's probably at this point about, I would say, 70% family law and then the rest school law on the parent-student side. I also, I do still consult with a school district to keep myself grounded in that area, working for the school district and working with teachers and parents and students on that side, and actually working directly with kids, which I still very much enjoy. But I would say family law and school law form the bulk of my practice.
You know, Dave, I guess a lot of our listeners probably don't really understand what school law is. Can you give us an overview and whether there's federal, state laws, or how it all works with school law?
Sure, absolutely. So the work that I do is primarily with students and parents, or parents on behalf of students. And it may be interesting to note that under federal law, there is no right to education except for kids who've been identified as having disabilities. So federal law comes in when we talk about students who need, for example, an IEP or special education services, or perhaps a 504 plan and accommodations and supports that they receive through the 504 plan, both in K through 12, and then they can take with them to college. And then state law comes into play for all students. So the Illinois State Board of Education kind of oversees all of that. We have laws. So, for example, the Illinois School Student Records Act, which governs how schools have to deal with student records. And then we have state regulations and rules for how state laws and the federal law are implemented.
Wow. I guess that sounds like it's really complicated. It seems, is it one of those areas of law that it's important to seek legal consultation about?
I think it is generally, and it depends upon the particular situation that parents are concerned about. So I think from my experience as a parent and as an educator, I would say, thankfully, most issues and concerns can be resolved by working directly with a student's teacher or with the administration or perhaps with the school board if necessary, or the administration. But there are times when, for whatever reason, because, for example, of a significant discipline incident that might result in expulsion, or if a student has significant learning challenges or behavioral challenges and they need a certain level of support or services or resources that, for whatever reason, the district is unable or unwilling to provide, sometimes legal counsel is necessary to help parents navigate those processes and procedures.
Is it fair to say there's a yin and a yang with, districts have finite resources and children with special needs require more resources? Is that fair?
That's right. And districts do receive funding, federal and state funding, to help meet the needs of students who have been identified with disabilities. But money is always a challenge. It's always a barrier. And sometimes there are disagreements with, for example, the level of support that a student might need. A parent might believe that their child needs more support, which costs more money. A district may feel like the least restrictive environment is, for example, their home school in the general classroom. There may be disagreements about that. Or conversely, a student may have significant behavioral challenges, and the district feels like that student needs more support, needs a more restrictive environment, and the parents don't want to remove their child from the home school, from their friends, from the non-disabled peers. And so that's where those conflicts can arise.
Is it something? Is the school supposed to lean towards mainstreaming kids with special needs?
The laws that students with disabilities have to be educated in what's called the least restrictive environment. And the baseline least restrictive environment is the home school with their non-disabled peers. And then from there are varying sort of increasing levels of restrictiveness that we can look at. Or there's a continuum of services and placements that range from special classes within the home school to an alternative therapeutic learning environment to a hospital placement, a homeschool placement, and then residential being the most restrictive.
Now, to help clear up any ambiguity, when you say homeschool, how do you define that?
So homeschool in the special education context would be a student who's educated at home, but who receives educational services and related services provided by the school. So push into the services that are pushed into the home. And that's a very restrictive level of placement. We saw a little bit more of that during the COVID pandemic when kids had significant medical needs, and because of those needs, they couldn't risk being exposed to the virus by being around their peers. And so we saw a little bit more of that during COVID. We're seeing a little bit less of that now.
So can you help me understand what school district child find obligations might be?
Sure, absolutely. So under federal law and then state regulations, districts have an obligation to identify or do their best to try to identify students who may have disabilities and who may need special education related services. And so from basically from birth on, and whether a student is in the public school or a private school, districts have an obligation to try to identify those kids who may need extra help and support.
What's the special needs? I mean, what are like the major ones? If you could list some of the major ones.
Yeah, sure. Absolutely. So there are a number of different classifications that we look at. I would say probably the most common is a specific learning disability. And so that would be a learning disability in any one of several different academic areas. So reading, mathematics, written expression are the big three. And then within those, there are other specific narrower areas. Then we could have an eligibility for a classification of other health impairment, which tend to be things like ADHD or anxiety or a significant health issue. Maybe the student has cancer or something like that. And then we have, there are others. Autism is something we're seeing more and more frequently over the last 2 decades or so. And then emotional disturbance or emotional disability, where a student has difficulty, for example, developing and maintaining relationships or demonstrating accepted behaviors under normal circumstances.
How is this addressed on let's say, a multi-tiered system?
It's a good question. So the law requires districts, as part of identifying students who may have disabilities, there's a process that used to be called RTI, response to intervention. Now it's called multi-tiered MTTS, multi-tiered systems, where we look at, there's 3 tiers, tier 1, tier 2, and tier 3. And we look at identifying kids who need additional supports. And then within each tier, we provide more supports, more specific supports. And then we collect data on those supports and interventions to determine whether or not it's working or we need more intervention and more help. And eventually then at the top of that triangle, we get to a place where students can be identified as needing special education.
Do students have different rights or any rights in private school versus public school?
Yeah, private school students would have the right, if necessary, to be evaluated by the public school district to determine whether or not they might be eligible for special education. And then each district decides. So let's say, for example, a student is at a private school, they are evaluated. It is determined that the student would qualify for special education. Then the student and his family or her family could choose to keep the student at the private school, and the district may then provide certain types of related services to the student. So, for example, the most common being speech and language services. Or the family could choose to enroll their student in the public school where they could access the services and supports they need based upon an IEP team's determination of what those needs are and what those services should be.
Now, you mentioned earlier about college. And so if someone gets an IEP in high school, how does that translate into college?
So an IEP will terminate when a student graduates from high school unless they need services, transition services, but that would be provided through the school district until age 22. When a student goes to college, if they still need accommodations, they would then ask the college to implement a 504 plan. So a 504 plan would be, what accommodations would they need to be successful in college? So the most common thing would be something like extended time on tests, or perhaps access to class notes, or perhaps an alternative testing situation or environment. Those kinds of accommodations that under Section 504 a person could take with them to college, and frankly, even into employment, they might need a 504 plan and certain accommodations based upon their disability in the work environment as well.
So you mentioned extended test taking. Does that apply to standardized tests like the ACT or something like that?
Absolutely. Yep. So any test that a student would need extended time for, college board tests, AP test, ACT, SAT, all of those things. And then there's an application process that schools will help students and their families go through in order to be approved by the governing body for that particular test. So, for example, again, with AP, it's College Board.
Now, with respect to where does family law and school law intersect? How can you explain that?
Right. So, it's not uncommon for parents with young children to choose to get divorced. That happens, commonly. And in those particular situations, when you have a child who's school aged, you have to determine through the courts who's going to make decisions about the child. And there are a number of different areas that parents have to make decisions about a child. Obviously, healthcare, extracurricular activities, religion, and education is a big one. And so most commonly, when parents can get along, they're going to share decisions or share decision-making about a child's education. And where school districts commonly get confused about this is what's most important is what does that parenting plan or agreement or the allocation judgment say about decision-making? And then so let's say it's shared decision-making and parents can't agree. School districts are commonly asking themselves, well, what do we do when parents can't agree? Well, that's a tough question to answer. But the best example I could give is parents have to consent to special education services. And one parent could come in one day and say, I want my child to receive an IEP and services. And another parent could come in the next day and say, I want to terminate special education. And that's tough for a district to know what to do. Generally, it's the parent who doesn't want it who prevails. And then parents have to go either back to mediation or back to court to get a judge to decide who's right or whose will or wishes are going to prevail with respect to what the school district has to do.
So it's interesting how I'm seeing a broad intersection here between family law and school law. And I was just thinking, I believe oftentimes when parents separate, they live in different school districts. How does that affect the child?
Yeah. So again, that we look back to what the parenting plan says, and generally what districts will honor the parents' decision about where their child will go to school, as long as one of the parents lives within the boundaries of the school district. And as long as the parents can get the child to that school districts will usually honor the wishes of the parents in terms of which school their child will attend.
Well, and I was just thinking, my mind was wandering while you were talking. I apologize for that, but I was wondering,
Mhm.
how a child identifies themselves, does that have anything to do with family law?
So in terms of gender identity, do you mean?
Yes.
Um, that's a great question. I'll tell you, to be honest, I have not encountered that issue in my family law practice, but I would imagine it would, because again, decision making falls to the parents. And so if one parent is okay with a child identifying that himself or herself as a different gender and the other is not, that creates, I think, some legal challenges that would have to be addressed through mediation and perhaps through the court.
It seems like that's probably an issue you're going to be dealing with sometime in the future.
It could be,
Yeah.
absolutely.
It's interesting because, for my generation, we're still getting used to, the gender identification issues, and I perhaps misspeak. I try not to, but I try and respect everybody here. But with respect to things, our with respect to is it the child's choice, or there's something that the parents work out as to what's like? Does the child's opinion matter? Is what I want to ask you as to
So,
what school they go to.
so generally, no. It's the parents' wishes and what they're able to agree to is where the child goes to school. I suppose once a child reaches the age of 18 and they reach, the age of majority where they're able to make those decisions for themselves, then they would certainly have more choice in where they would go to school. But until that point, that decision falls to the parents.
Okay. Well, with respect to children,
Mhm.
um, when it comes time for college, does family law impact financial responsibility?
It does, yeah. And this is one of those areas of the law that's unique in that if mom and dad stay married, the kid has really no rights with respect to requiring either parent to contribute to his or her college education. Mom and dad can say you're on your own. But when there's a divorce, the law, Section 513 of the Illinois Marriage and Dissolution of Marriage Act, says that the court may require one or both parents to contribute to the child's college education. Now there are rules and sort of caps on that. So, for example, the cap is set at what the cost of tuition, room, and board for the University of Illinois. So no parent's going to get stuck with footing the entire bill for a really expensive private school, for example. But both parents could be forced to pay for some, if not all, of their child's college education simply because they chose to no longer stay married to one another.
So to get that straight, so if you're married, you don't have to pay for your kids' college, but if you're divorced, you may have to pay for your kids' college.
That's right.
Okay. And do you know the policy reason behind that?
No, I don't. I haven't studied that deeply. I don't know. I don't know.
It doesn't matter, does it? It's
Yeah,
just the way it
yeah,
is.
yeah. So I guess the question would be, what's the policy reason for not requiring married parents to pay for their kids' college? I can think of lots of good policy reasons why unmarried parents might have to. Yeah.
Yeah. You would think it would be the same. The same.
Mm-hmm.
It's interesting how when parents decide to get divorced, then there's an additional burden placed on many families.
Yep, there is. Absolutely.
With respect to divorce and children, do you have any advice to parents that are going through a divorce?
Sure, absolutely. I mean, I think to take advantage of mediation in Cook County, mediation is going to be required if parents can't come to an agreement on the best interests of their kids. In other counties, it might be recommended but not required. So to use mediation that's available in Cook County, it's really affordable. If necessary, to consider counseling supports, therapy supports, both family therapy with the kids and then individual therapy as needed to navigate these challenges. It's not easy. It's not easy going through divorce anytime, let alone when you have school age kids. It's a challenge for everyone involved, and something that can be done well. It can be done well for sure if parents are able and willing to communicate, to work, to try to compromise. But it's a challenge. It's difficult.
I was reading about special ed kids and expulsion. Can you explain, are special ed kids, do they have any benefits because of being a special ed kid?
Yeah. So one of the things that has to happen if a student with an identified disability is being recommended for expulsion, if they have, for example, an IEP or a 504 plan, before the expulsion can happen, there has to be what's called it's a manifestation determination meeting. It's a meeting that's held, including the parents and the student and the professionals, to determine whether or not there's a direct relationship between the disability and the behavior that is now being looked at for the student to be expelled. And if there is a relationship between those two things, the student can't be expelled. He doesn't necessarily have to stay in the home school. They may have to find an alternative educational option for him or her, but the student cannot be expelled if there's a direct relationship between the behavior and the disability. So, for example, if a student, I don't know, maybe impulsively brings a weapon to school because he's getting bullied and he's worried about his safety, then the question becomes, is there a relationship between that impulsive decision to bring a weapon to school and the kid's disability? The kid has an identified disability like ADHD, where one of the common effects of ADHD is impulsivity, or an emotional disturbance, or is autistic, where one of the common effects is impulsivity, then it's easy to find that relationship, and then that protects the student from being expelled.
So it seems like being special ed can really be a benefit. We've discussed it can get you unlimited or additional test taking time, right? It can prevent the district from expelling you, right, and get you special resources from the district. What happens if the district doesn't honor the special ed laws and respect them?
Sure. So then that's where people like me are often consulted with and retained to help parents advocate for their rights. And so in the special ed world, when there are disagreements, we try to work that out. Again, at the first level of resolution is with the parent in the school. The second level of resolution, when they hire an attorney, is the parent's attorney and the school district's attorney consult and try to work out some resolution. If a resolution can't be reached, then the next most common step is for one of two things. Either the parents request mediation through the State Board of Education, or the parents skip right over that step and file a due process complaint against the school, essentially to sue the school district to make sure their rights are upheld. And then there's a long process. Due process is a long process whereby at the end, a hearing officer makes a ruling. Sometimes it's in favor of the district, sometimes it's in favor of the parents. And then along with that, if it works out in favor of the parents, they can ask to recoup attorney's fees.
Now, it seems to me that all this takes time, and by the time it's done, oftentimes the child might be done with that school. Is that fair?
That is fair. There are some safeguards in place for that. So, for example, if a school district is recommending a change of placement for a student with an IEP to a more restrictive out-of-building placement, the parents can invoke the magic words are stay put. They can invoke stay put, which means the student isn't going anywhere until the litigation is resolved. And then at the end of that litigation, the result may be that the student has to move, or maybe the student is able to stay.
So I've heard of school districts being required to spend very large sums of money to send certain kids with special needs to private schools. Can you explain why or how that works?
Well, the federal law requires, students with disabilities are required to receive what's called a free and appropriate public education, or FAPE. And if an IEP team determines, or a hearing officer determines, that the only way a student can receive FAPE is by this really expensive therapeutic program or residential program, then the school district is required to pay for that. I mean, there are funding mechanisms from the federal government that can support some of that, but school districts do have to come up with some money to pay for those placements.
What are some of the challenges that you've seen as a school law attorney in terms of how the kids handle divorce from an emotional perspective?
Mm-hmm. I mean, I think, like I said before, dealing with divorce is hard for any child, regardless of whether or not they have special needs. But when that happens together, it can be even more difficult. So when I worked in schools for a long time before becoming an attorney, worked as a psychologist, and commonly provided counseling supports for kids whose parents were going through a divorce. So those supports are available in most schools for students who are open to accessing those resources, and for parents who want their children to access those resources. And schools, I think by and large, I mean, they have a heart for kids. They work really hard and do a great job to support kids. And the work is hard. It's challenging. It really is. And most educators do a great job. And sometimes they fall a little short, and that's where parents need to advocate for their kids.
Do you think it's a good idea for parents to discuss with teachers that there is something going on at home?
I think that's a case by case, very fact specific question or situation. I mean, I think generally it's never a bad idea to give a teacher a heads up about, hey, we're going through a divorce. Just want you to be aware. If you see anything, if you see any signs that he's struggling, please let us know. Just that level of communication, I think, is helpful. And then, we want to honor a family's privacy and a child's privacy. So I think there probably is a line there that, most families don't want to cross, but generally some information is helpful.
You had mentioned earlier this court mediation process for children when parents are getting a divorce. Can you explain more about that?
Sure. So again, in Cook County, and in Illinois generally, when parents are getting a divorce, they're required to take a class. It's a 4-hour class to learn about and talk about how they're going to co-parent. So that's a requirement. And then with their attorneys, what we try to do is get to an agreed upon parenting plan. So again, how are they going to make decisions? What's that going to look like? And how much time is each parent going to have with their child? Regular parenting time during the week, holidays, vacations, during breaks from school. All of those things we need to make decisions about. And when we're unable to get to an agreement on any of those issues, ultimately what happens is we ask the court for help. And then the first step that the court will require, usually in Cook County especially, is mediation. And then if mediation does not work, then the next step is usually the court will either on the motion from the attorneys or on its own motion will appoint a guardian ad litem, or a GAL, an attorney who will essentially represent the interests of the child or children, and then conduct an investigation and then make recommendations to the judge as to how decision making should look and how much parenting time each parent should have.
What is an atypical, or is there such a thing of what a guardian ad litem might recommend?
It very much depends upon the nature of the family dynamics. And so, usually what a GL, I think, hopes he or she will be able to recommend is shared decision making and fairly equal parenting time, because I think generally when both parents are involved and both parents are making decisions and both parents are seeing the children on a regular basis, that's what's best for the kids. But there are lots of times and lots of examples where that's not what's best for the kids. If, for example, one of the parents has a drug or alcohol problem, or has violent tendencies, or serious criminal background, or things like that, that might require the court to make a different decision.
At what point does the child's opinion of where he wants to be come into play, if at all?
It does. That is one of, there are a whole bunch of best interest factors that a court will consider, and the wishes of the child is one of those factors. And how much the court will weigh the child's wishes depends upon what the court determines to be the child's maturity level, for example. So there's no magic age, but we usually look at, age 13, 14, where the court will start to consider more heavily what the child wants.
And I imagine once the kid starts to drive, he can pretty much do what he wants at that point.
Yeah, I think generally that's true. I mean, every judge is different. Some judges are hardcore in requiring that the child follow whatever the parenting time is, whatever the parenting plan says. But when they get to be 16 and they're driving and they're involved in extracurriculars and they have friends and maybe they have a job and maybe they're playing a sport, the court usually will grant more flexibility in the plan, in the execution of the plan.
It seems challenging how a court might impose consequences on a child for not following a parenting plan.
Well, and right, there are no consequences for the child. The consequences are on the parent, on one or both of the parents. So an extreme example that I'm familiar with is, a child was turning 18 years old within a matter of a couple of months and decided that he didn't want to honor the parenting plan anymore. And the judge said, no, you're going to honor it. And mom and dad, you're going to make sure that the child honors it.
And that sounds like good parenting.
But it's hard to do, especially, you have a child who's strong-willed and who maybe is large and strong, and, you're past the point where you're going to physically be able to force them to do anything. So you have to try to encourage it the best you can.
Well, I think the point that judge might have been making is, as parents, you're still supposed to provide a cohesive parenting style. Possibly, but I'm not sure what that judge was thinking. Who knows for sure, right?
And that's an extreme example for sure.
Yeah. And well, that's really interesting. Dave, I can't thank you enough for being a part of the show, and you've enlightened me greatly on two areas of law, that being school law and family law. I'd like to thank you and let everyone know we're signing off from Arlington Heights, Illinois, a suburb of Chicago. Have a good day.
Thank you.
You've been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.